Welcome back. This is day 2 of our virtual Hospitality Law Conference Series 2.0. Today is Wednesday, May 5th. It's 10 a.m. Central Time. We'll be using Central Time when we announce times, and we'll try to identify it as Central Time. Yesterday, we had a terrific lineup of speakers, and of course, you'll be able to access those again on our YouTube channel that Taylor will send out an announcement about. And of course, you can share that with other people in your businesses and firms if you'd like to. I'd like to remind everybody that at the end of each session today, there will be a survey, one question that just asks you if you need CLE credit for that particular session. So please be sure to stay until that survey pops up after each session. We want to be sure that you get credit where credit is due. I do also want to remind everybody that in October 6th, actually, I say Washington, D.C., it's actually in Arlington, Virginia, but at the beautiful Army-Navy Country Club, we will be venturing out, trying to host face-to-face. We've set it up as a hybrid right now, and I think it'll probably continue to be executed that way. But we'd love to see you for a one-day hospitality law conference in October, next door to our nation's capital in Arlington, Virginia. But if you've never been to the Army-Navy Country Club, it is something to behold. So I hope you can join us there. Well, I hope everybody's healthy. And just as a reminder, after each session this morning, we'll have a few minutes for you to take a break, get a snack, refresh your coffee, stretch, take a breath, and we'll be good to go. And then finally, in terms of logistics, feel free, once the speaker has finished with their preliminary remarks, to chime in with a question by unmuting, or feel free to send a question through the chat vehicle. I do want to request that if you're not speaking and during the breaks, that you remember to unmute, and if you want, stop your video, and it's helpful with the speakers, obviously. Okay, everybody. Well, thanks for joining us. We've got a great lineup today. I'm excited to have this first speaker, as always, kick us off. Alden has been with us many times, and we just absolutely love having him. Alden Parker is the regional managing partner out of the Sacramento office for Fisher & Phillips law firm. Fisher & Phillips, if you don't know, is a national law firm representing employers. And Alden focuses on the restaurant industry, and he's co-chair of the National Hospitality Industry Group for Fisher Phillips. He has, as you can see in the bio slide, he's been representing restaurant employers for 20 years and has defended over 500 lawsuits against restaurant operators. He's a member of the prestigious Legal Center Partners for the California Restaurant Association, and also a member of the Employment Law Center for the National Restaurant Association. He's here today to talk to us about the tip credit wage. Lots of pitfalls there. Alden, take it away.
All right, thank you very much. And I'm normally joined by my partner, Emily. She does a great job too out of Kentucky, and our Louisville office has a lot of restaurant experience too. And we both work on tip pool and tip credit issues quite a bit. I'll tell you at least where a lot of these comments are coming from. What I'm hearing as business picks up and people return to our restaurants are that, one, labor is scarce. We can't find labor, particularly in the back of the house. Two, everybody is spending money, the customers that are allowed in our place, like they just got off of a merchant marine ship with a fresh paycheck, and they're spending money like drunken sailors. And we simply don't have the labor to go ahead and support some of that. And everybody's doing their best to be able to give the customers an experience they're used to. Those two issues are somewhat in conflict. And one of the tools that some people use are tip sharing policies. And there's been quite a bit of activity recently that I want to make everybody aware of here at the federal level. What we're going to be talking about today, and the title of the presentation is the deep end of the pool, and whether these mandatory tip sharing policies are still legal, and if they are, really what are the boundaries of those, and those boundaries have been recently redefined. So it all starts with, when we're talking about tip sharing and tip credits, we're talking about the minimum wage. There are a federal minimum wage of $7.25 currently. We've certainly had a lot of talk about $15 per hour, and the issue of tipped wages has certainly been in the news as well as we start to talk about this. Many states have already gone ahead and they either have plans to increase or their minimum wage is much higher. And then you'll notice that depending on where you're operating, some states will allow for tip credits, some will not. The statements out of the federal administration are that there should be a national minimum wage of $15 an hour. And they are tying this idea to working 40 hours a week and either being above or below the poverty line. We know with tipped employees, especially in some operations that are either white tablecloth or even family dining, tipped employees, even if they're making the minimum wage on their hourly work, are doing much better than the poverty line. And so for our industry, these statements by the administration ring a little hollow when we're talking about tipped employees. But we want to go ahead and understand all of the different possibilities we have here. We saw a House coronavirus relief bill propose that increase following what many states, including California, did long ago with stepped increases that would take it to $15 minimum wage, increasing tipped minimum wage increases from $2.13 to $4.95 per hour. And then this also went ahead and proposed an elimination or tweaks to tip credits. They wanted to go ahead and attack that part or take that tool away. It did not make it through the Senate, but obviously with the statements coming out of the administration, that was the only thing that stopped this from ultimately going into play. Whether there's a renewed interest or it goes ahead and gets carved out into a separate bill where this becomes the focus, we can probably expect that possibly as an election year issue, and we'd be watching very closely to see what they want to do here. So when we get into the idea of a tip pool, there's a couple different tip pools that everybody has been working with in the past. I want to define those for everybody, because that will help us understand what the DOL's current position is on this. You're going to have to check your own state. I just want to set the groundwork for what the federal government is going to look at under the Fair Labor Standards Act with the Department of Labor. So there's a traditional pool with a tip credit. Those are for tip credit employees, typically in the front of the house. There have previously been tip pools with both the front of the house and back of the house included under a chain of service theory, that the back of the house is very important to the success of the front of the house. And all of that is in the chain of service. And the Department of Labor has really been looking at those issues quite a bit and ultimately changing those quite significantly as we go through. So I picked these pictures intentionally because this really has been a real seesaw moment in tip sharing policies. Currently, if an employer takes a tip credit of up to those $5.12 per hour, then we're looking at a situation where a traditional tip pool is going to be limited to employees that customarily regularly receive $30 or more in tips per month from customers. So those are generally going to be limited to your servers, your hosts, your bartenders, front of house staff. Working different employees into some sort of dual role where they might be busing, expediting, doing direct table service might help establish more people that could be included in that customary tip pool. Previously, for a short period of time, front of the house and back of the house who were not traditionally tipped employees could have participated in that. And I'm going to talk about that change in a moment. What's regardless of what tip system you have, though, one of the real important things to understand is that all owners, supervisors, managers can't participate in these tip pools. And we need to make sure that they are specifically out of any policy, that we specifically put that into a policy that we write so that it's very, very clear that those individuals are not going to go ahead and be included. The fulcrum, if I'm looking at a sort of seesaw where we get a lot of questions, are what about a shift supervisor or a shift lead that we're paying hourly but is managing the floor and calling employees off when it gets slow or bringing someone in when it gets really busy? Can they participate in a tip pool? If they are an hourly employee and generally they're going ahead and providing direct table service so that they would normally receive that $30 or more in tips per month, then we are looking at a situation where they could go ahead and participate. It's a gray line. It's one that is certainly subject to attack quite often. But the keys, I think, there are typically our leads don't have the power to hire and fire or discipline. They're simply managing the floor. They're typically hourly paid employees and they're providing direct table service. They're not simply going ahead and sitting there and managing a floor. They're directly going ahead and providing that table service that qualifies them for that tip pool. But all of those are real factual questions that you'll have to work through in order to understand this. And so I wanted to talk about how we've really seen the DOL evolve on this issue and really how they're trying to sort of drain the tip pool at this point. So in December of 2020, not that long ago, there was a final rule that was announced under the previous administration that was scheduled to take effect in early March. It removed portions of the regulations that prohibited employers that don't take a tip credit from implementing those non-traditional tip pools. So those are the tip pools where we can have back of the house chain of service employees participate in the pool. It was an excellent way to attract back of the house employees in tight labor markets and go ahead and keep their hourly wage or hourly amount in check because we were going ahead and allowing them to participate in tip pools. So the DOL went ahead and announced that final rule and was going to allow, by removing the portion of the regulation that prohibited this, was going to allow the chain of service rule to go into effect. It explicitly prohibits the employers from taking a tip credit. That means the managers and supervisors. That's been fairly accepted for a long time, was not real shocking. It amended the regulations to state an employer that collects tips to facilitate a mandatory tip pool has to fully redistribute the tips. And what we wanted to go ahead and encourage everybody to do in order to meet our burden there is make sure we're keeping a log of money into a pool and money out. That record keeping component helps us make sure that we're complying with that portion of the regulation so that every nickel, every dime is accounted for, probably down to the penny. Incorporates some requirements regarding penalties into the regulations. And that was all going to go ahead and bring what we thought was a fairly balanced approach to it. The pool was going to get bigger. More people were going to be able to participate in it. And we were going to put some tight controls on record keeping, who was prohibited, what type of penalties people were going to go ahead and get if you went ahead and violated that. There was a record keeping requirement for employers that do not take a tip credit, but collect the tips to operate a tip pool. There was going to be some guidance that went into the rule. There was going to be some regulations that address the payment of tip pools. All of those things were seen as helpful to go ahead and control and give guidance to a lot of people. So January 20th saw a new administration come in and immediately go ahead and issue a regulatory freeze memo. That went ahead and caused this final rule to be stayed and not go into effect. The DOL withdrew their opinion letter on non-traditional tip pools. that was the first indication that we got that the portion where back of the house employees were going to be allowed to participate was going to come off the table and probably not stick. And the DOL then proposed that parts of the rule get delayed at first until April 30th and then ultimately to December 31, 2021. So I wanted to update everybody about what the latest is, because it's very, very fresh. And we wanted to make sure everybody has a very current picture of where we are. So April 28th, a few days ago, the final rule went ahead and got announced with a partial delay of portions of it. And so the three portions that were delayed certainly did include this chain of service requirement. It also delayed the civil money penalties under the FLSA, and it went ahead and pushed everything out until at least December 31, 2021. So unfortunately, where that leaves us is that we're looking at direct table service individuals that are the limits of our tip pools. And we need to make sure that under the FLSA, quite frankly, regardless of whether your state allows it or not, you're going to go ahead and have to limit your tip pools to those individuals providing providing direct table service rather than chain of service. It's an unfortunate limitation, and it directly impacts this issue between getting your back of the house individuals in order to meet the current labor shortage, going ahead and getting them some form of compensation to attract those workers, either from unemployment or from another employer. And the amount of money that the front of the house is experiencing in terms of tips due to this spending spree that many people are currently on. We don't know whether that will equalize in a few months as federal stimulus money wanes or more people come off of unemployment rolls with increased benefits. But currently, we certainly are feeling the strain of not being able to attract enough back of the house employees, and certainly a lot of people enjoying the front of the house tip bonanza, I think I would go ahead and label it as. So unfortunately, employers that have been looking at tip pools and instituting tip pools since the December rule was announced have to now pivot quite abruptly and redo their tip pools as of April 28 to make sure that they are appropriately limited. And unfortunately, if you're in a state that allows something broader, you're going to be hamstrung by that provision in the federal rules. So I went ahead and added some tip credit compliance ideas, something that will help you go ahead and include. One of them is a notice that lays out the amount of cash wage that's going to be paid, the additional amount of claimed as a tip credit, the tip credit claimed, all the tips received by an employee, so we have a proper amount of tracking. And ultimately, I really do feel you have to go in with a tip pool with your eyes wide open. If it's a mandatory tip pool, you need to make sure that you're looking at this from the standpoint of compliance is going to be key. And ultimately, if it's too limited, whether you should really take on that burden or not. To me, there is a natural camaraderie in the front of the house of tipping out people. There's certainly employees that will generously give to those that support their level of service that they're giving to customers. And that is different than a mandatory tip pool and doesn't require the level of oversight. Where we can't spread out the tip pool to encompass everybody, to me, there is a cost benefit analysis that everybody's going to have to consider about whether to take on this burden and spread out amongst employees that are already getting tips regularly already. Some are doing it currently because your bartenders, we don't have in certain states people sitting at a bar still. And so we're looking to be able to appropriately compensate bartenders and get them sharing in the tip pool since they are customarily individuals that get tips. But outside of that, everybody else is interacting with the employees already. And if they are incorporating that into some level of direct table service, they could either share in a tip voluntarily, or you could still make them a mandatory tip pool to get your host, your hostess properly compensated. I included some issues that come up involving tipped employees, but I want to give everybody some time to go ahead and ask some questions. This really has to do with overtime and tipped employees and how to do those calculations. And so you'll be able to see that in the slide deck and work with those. And you can always feel free to call me or go ahead and hit me up on email anytime you want with any questions that you have.
Thank you, Alden. Man, right on top of it. Thank you for bringing us so up to date. Great discussion about the evolution of that law, because I know that was confusing for many.
Yep.
And hopefully we'll get some clarity between now and the end of the year, but we'll see if that works out. Alden, I just want to remind everybody, as we mentioned yesterday, in case they weren't with us, is that the Fisher Phillips website, FisherPhillips.com, right? It is a remarkable resource. And they keep a lot of things up to date, like COVID litigation you heard about yesterday, but a lot of labor information as well. Alden and his team do remarkable work in keeping that information up to speed, and often it's multiple state oriented. So I would go back to that frequently, especially if I was in-house and trying to keep up with multiple jurisdictions. So with that said, all in our time we have, I want to get to a question really quickly. I want to remind the audience you can chime in or send a question via the chat. But Alden, we talked yesterday a little bit with your partner, Andrea Ryan, about staffing companies and contracts with restaurant and hotel operations, because as you mentioned, the labor market is so challenging right now. Many are turning to these hospitality staffing programs. Andrea was kind enough to give some good tips around that, but I was interested in hearing from you around California, and particularly regarding these contracts. And I know you guys have some specific laws that perhaps the federal government is looking at adopt something similar to it. Could you talk about that for a bit?
Sure. You're awfully kind in your description of our laws out here, because they're nothing short of soul crushing to a lot of employers. And unfortunately, they are currently being exported nationally. So if we're looking at California's economy, we're definitely a net exporter of bad employment laws at this point. When we're dealing with contracted individuals at this point, certainly in California, there's two main lines of attack that people are taking under the law with respect to those. One is that our joint employer rule is pretty liberal in terms of how they're going to approach that. With contracted employees, contracted individuals on our sites doing a lot of the roles that we otherwise would hire direct employees for, that's going to be a tough sell out here, where they're doing the same activities that they would otherwise be doing if there were an employee. And so the contract itself is going to sort of be your beachhead, making sure that you're shifting indemnity for what ultimately could be a wage and hour violation to that contractor. We also have some unique labor codes out there that do talk about if an employer or if a company is going ahead and signing a contract with another business, and that contract does not sufficiently provide for enough money in the contract for the employer, the actual employer, to go ahead and pay the appropriate wages, then the contracted company can actually be responsible for those. So that's another line of attack. The other problem we have out here is AB 5, which was an attack on gig workers and transportation workers that were operating as independent contractors. And one of the ABC tests that got developed through that really focused on the idea that if it's central to your business, the work that the individual is doing, if it's part of your business, and what you're offering to people, then they can't be independent contractors. Well, if you're contracting for people in the back of the house, the front of the house, people in the hotel, it's going to be hard to meet that test. Now, the most interesting part of this is it was an attack at first on transportation workers and gig workers. The courts have gone ahead and invalidated its application to the transportation industry that is in interstate commerce. And then we had a proposition that went ahead and exempted the gig workers. So the whole reason for it now has been eviscerated, and the rest of us are the ones paying the price. That's unfortunately where we are at this point.
Yeah, that's challenging, because it sounds like, I think you just said this, I just want to recap it, is that it would be darn near impossible to classify any worker in a restaurant or a hotel as a contract worker, given the criteria that I think you just mentioned. Is that fair?
I think that's fair, unless you're talking about someone coming in for maintenance, construction, something not central to the hotel's operations or the restaurant's operations, potentially an IT person coming in as an independent contractor to go ahead and make sure that your Wi-Fi system is correct or something like that. You're going to have some areas, but if it's providing what a restaurant or a hotel provides, that's going to be a tall order. And
yeah. So if we've got one of these agencies sending us temporary servers or temporary kitchen help, we're goners. Same thing on the hotel side with housekeeping, staffing.
We just want to make sure our contract shifts the liability to the contractor and that they're taking it. I'd be reticent to go ahead and enter into a contract that where we could be potentially liable. We have no control over whether someone's getting a meal and rest period or being paid appropriately overtime or their paycheck's right. And the contract says if the provider gets sued, we're on the hook. It's our liability. You've got to be able to shift, and the contract should require the person providing that labor to you to comply with all federal and state and local laws.
Yeah, listen, I think that's really significant about shifting the burden of responsibility there. But I want to mention one other thing around that, and I assume you agree, is that indemnification clauses are tossed around pretty liberally, and they get included in agreements. The challenge is, a lot of people don't recognize, is there needs to be some money behind that indemnification agreement, right?
Right.
And so I'm assuming we're looking for insurance or being named as a co-insured. Is that also in your scope?
Yeah, that's correct. I mean, if you get sued by the individual that you were using as a contractor, they can get a judgment against you as the operator. This indemnification clause is not going to go ahead and stop the actual lawsuit from the person that's claiming they were an employee. You're just taking the contract and saying, hey, look, whatever I get hit for, it's over here. Whatever cost of defense, it's this person doing it. Well, if that person is a fly-by-night, gone, gone in the middle of the night, uncapitalized, you're going to still be on the hook, and that contract's not going to be worth anything. So we shouldn't go in blind. There are ways to manage this issue, but you really do need to be thinking about those issues as you enter into them. And unfortunately, as operators, we're screaming for the help right now. So it's a very emergency need that sometimes leads to us not being as strong on the terms as we should.
Yeah, that's a great point too. And I was just reading, I think it was this week, I think it just came out. I think that the matter was settled several months back, but there was a resort in Wyoming that kind of took it on the chin. And it appears, from what I read, I don't know all of the facts, of course, but it appears that it was a staffing agency that had some challenges. But of course, reputation-wise, it was the resort that really got the black eye. There wasn't enough information to glean who ended up having to pay, but you can imagine there was an indemnification clause in there. And as you just pointed out, you can still get sued and get the judgment against you. It's not going to preclude that from happening, for sure. Well, listen, we got just a few minutes remaining. I don't have any questions to chat yet, but I want to put you on the spot for just a second, if
Sure.
I can. I know you work a lot in this space. And so as we were talking about these contractors, part of the operation of the restaurant, where do you think valet parking services fall?
Well, I mean, I've long maintained that they're separate and not central to the function of the restaurant, and so that their individuals are also separately employed by someone else other than us. And I think we've got a pretty good argument there. They're not inside the four walls of the restaurant. It's an ancillary service that is being provided by a contracted company. And we can generally go ahead and pretty effectively negotiate those terms with the valet companies. But the same general principles apply. We don't want to be dictating too much the individual day-to-day operations of their employees. We want to stay as separate as possible. Complaints that come in don't get direct to the restaurant about the valet, which is what's going to happen is going to go to the contracted company, and we're not going to be dealing with them directly. There have to be some protocols that our managers utilize in those situations so we don't blur the line on whose responsibility that is.
Yeah, that control concept for sure. But do you suggest to restaurateurs that in their agreements with valet parking that there also be indemnification agreements and that there's insurance to back it up for the same reasons we talked about before?
Absolutely. And the real problem here is a lot of those places are not well capitalized. So making sure that there's an additionally named insured is just a vital sort of component of that.
Yeah, the valet parking services are not very well capitalized, right? Yeah.
Yeah, I mean the three things that I think are necessary in these contracts is indemnity and defense clause, a clause dealing with an additionally named insured, and a clause that says they are responsible for complying with all federal, state, and local laws. And all of those things. That way, if they've violated that portion and the claim is that they did not go ahead and comply with a state law and they're ultimately found not to have, then we can turn around on a breach of contract claim and say they violated the contract because they failed to do it. If they're gone, though, that's not going to do us much good unless there's insurance.
Yeah, that's a great point. Last question. I think I've got this one, but I'm not sure. I think for me, it's a bit of a gray area. In your mind, the expediter in a restaurant, just so everybody's clear, when I say use the term expediter, it's the facilitator, the person that stands at the line when the plates come out to make sure the apps go out sooner, right? The entrees follow in an appropriate period of time. The entire order goes out at once. They help put the tray together for the servers. In your chain of service situation, front of the house or back of the house?
Generally, the expo is front of the house in restaurants and considered to be providing direct table service. Okay. So you have the server, you have the expo, and then the real question under this FLSA rule is whether a busser could be considered to be someone that customarily receives tips. I think unfortunately, a fair reading of it is that they wouldn't be included in those mandatory tip pools as the rule is currently. Hopefully, they'll give some real thought to this issue come the end of the year. Between that and the right to recall out here in California, those are really two big issues that everybody's going to be grappling with this year. The right to recall is a monstrous piece of legislation out here that got crammed in and does affect hotels in the state of California. So if you want to learn more about that, feel free to email me or hit me up on Twitter at Cal Labor Law. I'm happy to go ahead and engage with you on that.
Well, Alden, just real quick, give us the gist of the right to recall.
Yeah, the gist is that the real evil parts are that you have to offer a position to anyone that was laid off during the pandemic. You have to give them 5 days to respond and tell you whether they're going to take the job. And it is silent to how many times you have to do this. And silence in California means that you probably need to go and do it over and over and over again, because the penalties amount to approximately $600 per day if you fail to do that. So if someone turns you down 30 times and tells you they've moved to Spain, this law suggests you still have an obligation to go ahead and go through this process until December 31, 2024 for some
Whoa.
crazy reason. And so it's all of the hotels and the businesses that go ahead and support the hotels. So your restaurants, your gift shops that are on the property and supporting those venues.
Yikes. Well, thanks for that. As always, a wealth of information. Thank you kindly for starting us off today in such a terrific manner. We'll look forward to seeing you again in the near future. Taylor, if you could put up the survey. And then Alden, if you could please stop sharing your screen.
Yep, no problem.
All of our logistics will be good to go. All right.
All right, excellent. Thank you, everybody. Happy to engage anytime. Just reach out.